Mr. Chairman.
Ian Lees-Galloway.
Thank you very much, Mr. Chairman. I would like to speak specifically to Supplementary Order Papers 101, which is in my name, and 107, which is in the name of Marama Fox. They both seek to amend Clause 167B, which is found in Part 4 of the Health and Safety Reform Bill. And they make important amendments to the limitation period for bringing a private prosecution. And they have been proposed by the two of us because of the interaction of the various clauses relating to limitation periods for prosecution, which are clauses 167 clause 167 plus 167A through C. And it's a bit of a technical loophole, but it's an important one for the House to address, sir, because the way those various clauses interact means that WorkSafe essentially has 2 years in which to bring a prosecution. So if WorkSafe determines that there has been a breach of the Health and Safety Reform Bill, and that it may meet the criteria for bringing a prosecution, they've got 2 years to decide whether or not to bring that prosecution. At the same time, sir, those potentially wishing to bring a private prosecution in the event that WorkSafe decides not to prosecute also have a 2-year limitation. Now the WorkSafe actually has initially 12 months in which to bring its prosecution, but can apply for up to an additional 12 months. Now, if WorkSafe just takes the 12 months that it is ordinarily able to take under Clause 167 and decides after that 12 months that it's not going to take a prosecution, then anybody wishing to take a private prosecution would have 12 months in which to take that prosecution. And that's perfectly acceptable. We're certainly very comfortable with that. However, if WorkSafe applies for the additional 12 months and receives that additional 12 months, takes the full 12 months and then decides not to prosecute, then there is no time remaining for anybody to take a private prosecution. Now, it may be rare that this could occur, it may be unlikely that this could occur, but it is certainly possible under the legislation as it is written that this could happen, that WorkSafe could decide not to prosecute and nobody else would have the right to prosecute either. So what I have proposed under Supplementary Order Paper 101 is that there be a 6-month extension that from the point where WorkSafe decides not to prosecute, that there would be a 6-month window in which a private prosecution could be taken. And I took this proposal to members around the House, one of which was Marama Fox on behalf of the Māori Party, and I understand that as a result, Marama Fox certainly indicated that the Māori Party could support that proposal from the Labour Party, and my understanding is that as a result of negotiations with the Government Party, perhaps because the National Party couldn't bring themselves to support a Labour amendment, that the Māori Party have proposed a 3-month extension. I think that's a little short, to be honest. I think the 6 months gives a fair window for a private prosecution to be brought, but certainly introducing a 3-month window is an improvement on the situation that we have right now, sir. Now, private prosecutions are actually incredibly important. They're an important check on the regulator. And we have had 2 recent important examples of where WorkSafe and its predecessor organisations decided not to take a prosecution, Mr. Chairman.
Ian Lees-Galloway.
WorkSafe decided not to prosecute, and the Council of Trade Unions decided that they would take a private prosecution. And that was an important step because in two cases which recently, the courts have actually recently decided on, the private prosecution brought by the Council of Trade Unions was successful. In fact, it was with incredible ease was the prosecution successful, with so much ease that there is a considerable question mark hanging over the decision by the regulator not to pursue prosecution. But it was an important check on the regulator, saying actually that these were two important cases where the regulator ought to have pursued prosecution. Now, whether the regulator thought that it was unlikely that they would get a decision in their favour, whether they thought it was going to be too costly, I don't know what drove the decision not to prosecute. But clearly, the ease with which the Council of Trade Unions got successful prosecutions should give WorkSafe pause for thought. And in my view, that is the system working. We need to have that check on the regulator to actually be able to expose those instances where the regulator frankly got it wrong, and it gives them an opportunity to learn from it so that in future, when they have that decision in front of them whether or not to prosecute, they'll be able to look back on the results of those private prosecutions and perhaps pursue a different course of action in the future. And it would be a shame, sir, if we found ourselves in the situation that is currently possible with the clauses drafted in the fashion that they are, that a private prosecution could not be taken. So just recently, we had the case of loader driver Charles Finlay, who in 2013 was crushed to death by a log while he was working in the dark. WorkSafe investigated, but said it could not find enough evidence of wrongdoing to prosecute the 45-year-old's employer, M&A Cross Limited. But M&A Cross actually pleaded guilty. That was how easy it was to get the prosecution when the CTU took a private prosecution. The employer actually immediately pleaded guilty. So I think there's a clear demonstration that WorkSafe got that one wrong. Also, the employers of 19-year-old forestry worker Eramiha Pairama, that was Puketi Logging, were found guilty of a charge under the Health and Safety and Employment Act relating to his death. Also, in 2013, the employer was found to have failed to take all practicable steps to provide their employee with a safe working environment, and particularly to ensure that he was not exposed to the dangers of work while he was being expected to manage on his own. These are two important cases that the Council of Trade Unions has taken and has been successful in. And so we on this side of the House see this ability to take private prosecutions as an absolutely vital component of the overall system. Obviously, the regulator WorkSafe plays an important role in enforcing the law, but we also have to have the ability, especially for the likes of the unions, to be able to play their part in enforcing the law as well. And so when WorkSafe fails in its duty, or just makes a wrong call. I'm not saying this is any dereliction of duty on the part of WorkSafe, just a decision which turned out in the long run to be the wrong decision. There is the ability for the Council of Trade Unions, or anybody else for that matter, to take a private prosecution. So I strongly urge members to support my amendment. I think the 6-month window is the more appropriate approach to take. But certainly my understanding is the government plans to support the amendment in the name of Marama Fox. I'm glad that by proposing the 6-month window, we've been able to manoeuvre the government into supporting a 3-month window. That is certainly an improvement on the current situation. It's a shame we weren't able to settle this at Select Committee. I actually thought for a period of time that this was going to be settled at Select Committee. That unfortunately was rejected by the MPs, but I do urge members to support preferably my SOP, certainly Marama Fox's SOP on this matter.
Chairman.